I didn't say a word when the fire marshal handed me the arson investigation report. I just set it down next to the federal subpoena I'd been drafting and watched the HOA president's face drain of color as she realized what those official seals meant. 23 years on the federal bench had taught me that the most devastating verdicts are delivered in silence. And after what they'd done to my home, I was about to teach Willowbrook Estates the kind of lesson that gets written into case law. The cabin had been my grandfather's before it was mine. Sitting on 12 acres of Virginia pine and mountain laurel that he'd bought in 1958, when this whole area was just logging roads and deer trails. I inherited it after 25 years of grinding through federal court cases, drug kingpins, and white-collar criminals who thought their money made them untouchable. All I wanted was a place to read books, restore old furniture, and maybe teach myself to fish without some defendant's attorney calling me at midnight with emergency motions. The cabin was a century old, hand-hewn logs with chinking that my grandfather had mixed himself, surrounded by stone walls he'd built to keep his sheep in and the world out. When I bought the adjoining 8 acres in 2019, expanding my property to 20 total acres, I thought I'd found the perfect place to spend my remaining years before mandatory retirement at 70. The first letter arrived on a Tuesday in March, printed on expensive letterhead with gold embossing that screamed new money and small authority. Notice of non-compliance, Willowbrook Estates Homeowners Association. I read it twice, certain there had been some mistake. According to their records, my property was subject to HOA covenants, and I was in violation for failing to obtain architectural approval for structural modifications to my home. The modifications in question turned out to be the new cedar shake roof I'd installed to replace the one damaged by a falling oak during last winter's ice storm. I'd pulled proper county permits, hired licensed contractors, and used materials that matched the cabin's historical character. But apparently Sandra Kellerman, the HOA president, felt that my 150-year-old cabin should conform to the same beige and white color. Schemes required for the McMansions that had sprouted around my property like mushrooms after rain. I drove through Willowbrook Estates. For the first time that afternoon, winding through perfectly manicured streets lined with identical colonial revivals, each one sitting on exactly 0.75 acres with regulation landscaping and approved mailbox designs. The development had been built on what used to be the Hartwell Farm, prime bottomland that had been sold off piece by piece as real estate values climbed. My property sat at the eastern edge of this suburban paradise, separated from the nearest house by a quarter-mile of mature forest and a creek that ran year-round. I'd never considered myself part of their community, and frankly, the feeling seemed mutual. In 3 years of living there, I'd received exactly one neighborly visit, and that was only because Mrs. Patterson's cat had gotten stuck in one of my oak trees. My first instinct was diplomatic. I called Sandra Kellerman's number and left a polite message explaining that my property predated the development by 60 years and wasn't subject to any HOA agreements. When she didn't return my call, I sent a certified letter with copies of my deed, survey, and title insurance policy, all clearly showing that my land had never been platted as part of Willowbrook Estates. The response came 10 days later, a formal notice of violation and a $500 fine for failure to comply with architectural review requirements. Attached was a copy of the subdivision's master deed, which claimed to encompass all properties within a specific geographic boundary, including mine. It was impressive-looking legal work, full of whereas clauses and municipal references, but it had one fatal flaw. I'd been reading legal documents since before Sandra Kellerman was born, and this one was about as legitimate as a $3 bill. When I called to request a hearing before the Architectural Review Board, Sandra informed me that my attitude of non-compliance had already been noted and that future violations would result in escalated enforcement actions. I asked what that meant exactly, and she said I'd find out soon enough. The next morning, I found my driveway blocked by orange construction cones and a sign, declaring it a private road subject to HOA maintenance requirements. The sign also informed me that I'd need to pay a $200 monthly road maintenance fee to continue using what had been my own driveway for 3 years. I moved the cones, drove to work, and spent my lunch break researching Virginia property law with the kind of focus I usually reserved for complex federal statutes. That evening, I found my mailbox had been removed. According to another official notice taped to the post, my mailbox design didn't conform to community standards and had been confiscated pending my submission to the architectural review process. The notice was signed by Sandra Kellerman in her capacity as Community Standards Enforcement Officer, a title I was pretty sure existed nowhere in Virginia's Homeowner Association statutes. I drove to the post office, filed a mail forwarding request, and then spent the next 3 hours reading every document related to the Willowbrook Estates development that I could access through the county clerk's online database. The pattern that emerged was both fascinating and infuriating. Sandra Kellerman had moved into Willowbrook Estates in 2018, been elected HOA president within 6 months, and immediately began expanding the association's claimed authority beyond what was actually written in the covenants. She'd filed liens against 2 other properties for violations that existed only in her own interpretation of the rules, successfully forcing both homeowners to sell rather than fight. One was an elderly widow whose excessive flower garden had apparently violated the landscaping requirements. The other was a young couple who'd painted their shutters navy blue instead of the approved colonial blue specified in guidelines that Sandra had apparently written herself. I realized I was dealing with someone who viewed the HOA presidency as a personal fiefdom, who discovered that most people will pay fines rather than hire lawyers, and who'd never encountered someone with the legal knowledge to call her bluff. That was her first mistake. Her second was assuming that a federal judge would be intimidated by neighborhood politics and angry letters. Her third, and ultimately fatal mistake, was what happened on the night of April 15th. I was in my study, working on an opinion in a complex RICO case, when I smelled smoke. At first, I thought it was someone burning brush, but the smell was too close, too chemical. I walked outside and saw orange light flickering through the trees between my cabin and the development. My workshop, a small outbuilding where I restored antique furniture and stored my woodworking tools, was fully engulfed. I called 911, then stood in my yard watching 40 years of collected tools and half-finished projects disappear into the night. The volunteer fire department arrived 20 minutes later. But by then, there was nothing left but a concrete foundation and twisted metal. The fire marshal, Tom Brennan, was a man I'd known professionally for years through arson cases that had come before my court. He walked the scene the next morning with the thoroughness of someone who'd investigated hundreds of suspicious fires. The burn pattern was wrong, he told me. Too hot, too fast, too complete for an electrical fire. And there was something else. He found accelerant residue in 3 different locations, along with the remains of what looked like road flares. This wasn't an accident. Someone had deliberately torched my workshop, and they'd done it with materials you could buy at any hardware store. I spent that afternoon filing reports and calling my insurance company, but my evening was devoted to something more interesting. I pulled the deed records for every property in Willowbrook Estates, cross-referencing them with the county's tax assessments and zoning maps. What I found was remarkable. The development's master deed, the document Sandra had used to claim authority over my property, contained geographic descriptions that were off by nearly a quarter mile. Either someone had made a very expensive surveying error, or Sandra's legal authority was even more fictional than I'd suspected. The next morning brought another letter, this one more threatening than the others. Due to my continued non-compliance and the safety hazard created by the recent fire, the HOA was demanding immediate access to my property for a comprehensive safety inspection. If I refused, they would seek a court order and pursue all available legal remedies, including placing a lien on my property for accumulated fines and enforcement costs now totaling $3,200. The letter was signed by Sandra Kellerman and notarized by her husband, which struck me as legally questionable but perfectly consistent with the amateur-hour legal work I'd been seeing. I decided it was time to educate Ms. Kellerman about the differences between neighborhood politics and federal law. But first, I made a few phone calls. One was to Tom Brennan, asking him to expedite the arson investigation. Another was to an old friend who worked as an investigator for the FBI's white-collar crime unit. The third was to my clerk, asking her to research any pending cases involving HOA fraud or racketeering charges. What she found was enlightening. The Eastern District had seen a significant uptick in cases involving HOA board members who'd used their positions to engage in various forms of fraud, extortion, and illegal property seizures. Several had resulted in federal charges under the Hobbs Act, which covers extortion affecting interstate commerce. The pieces were falling into place beautifully. Sandra Kellerman had created a pattern of behavior that looked remarkably like a racketeering enterprise. She was using fraudulent legal claims to extort money from homeowners, had filed false liens against properties outside her jurisdiction, and if Tom Brennan was right about the fire, had escalated to arson when her other tactics failed. Under federal law, this wasn't just bad neighborhood management. It was a criminal conspiracy that fell squarely within my court's jurisdiction. I spent the next week building a case that would have impressed the prosecutors who appeared before my bench. I pulled corporate records showing that Sandra had created a shell company called Community Standards Consulting that charged the HOA $500 per month for services that seemed to consist entirely of sending threatening letters. I documented 8 separate incidents where she'd claimed authority over properties that weren't actually part of the development. I obtained copies of the fraudulent liens she'd filed, complete with forged signatures and false notarization. Most importantly, I traced the purchase of road flares to a hardware store receipt found in Sandra's trash, obtained through a process that was completely legal when conducted as part of a federal investigation into interstate fraud. On the morning of May 3rd, I drove to the Willowbrook Estates Community Center for what Sandra had called an emergency enforcement hearing. I arrived early, taking a seat in the back of the room as residents filed in to watch what they probably expected to be another routine disciplinary action. Sandra took her position at the head table, flanked by her husband and 2 other board members who looked like they'd rather be anywhere else. She called the meeting to order and announced that they were there to address my continued defiance of community standards and failure to pay legitimate fines. I waited until she'd finished her prepared remarks about community values and property standards before I stood up. "Miss Kellerman," I said in the voice I used for delivering sentences, "before we proceed, I'd like you to examine these documents." I walked to the front of the room and placed a stack of papers on the table in front of her. The first was Tom Brennan's completed arson investigation, concluding that my workshop had been deliberately burned by person or persons unknown using accelerants and road flares. The second was a federal grand jury subpoena issued that morning, requiring Sandra to appear before my court the following Tuesday to answer questions about mail fraud, wire fraud, and conspiracy charges. The room went completely silent. Sandra picked up the subpoena with hands that shook just enough to make the papers rattle. "You can't do this," she whispered. "This is just a neighborhood dispute." "Ms. Kellerman," I replied, "when you used the United States Postal Service to send fraudulent legal documents demanding money under false pretenses, it became a federal crime. When you filed false liens in interstate commerce, it became racketeering. And when you burned down my property to intimidate me into compliance, it became arson in furtherance of a continuing criminal enterprise." I let that sink in for a moment. What it stopped being, the moment you involved federal agencies and interstate commerce, was a neighborhood dispute. I turned to address the room full of neighbors who'd been watching this unfold with growing horror. For those of you who've paid fines or fees to this HOA based on Ms. Kellerman's claims of authority, I'd suggest you review the actual covenants and restrictions on your properties. You may find that you've been victims of fraud rather than violations of legitimate rules. The United States Attorney's Office will be very interested in hearing from anyone who's been financially harmed by false claims of HOA authority. The aftermath was swift and decisive. Sandra Kellerman resigned from the HOA board that afternoon and retained a criminal defense attorney by evening. The board of directors voted unanimously to rescind all fines and liens issued during her tenure, refunding nearly $47,000 to homeowners who'd been victimized by her fraudulent enforcement actions. The shell company she'd created was dissolved, and the development's master deed was amended to accurately reflect the boundaries of HOA authority, explicitly excluding properties like mine that had never been part of the original subdivision. The federal case moved forward with the efficiency typical of well-documented white-collar crimes. Sandra ultimately pleaded guilty to mail fraud, wire fraud, and conspiracy charges, receiving 18 months in federal prison and restitution orders totaling $73,000. Her husband, who'd been complicit in the notarization fraud, received probation and community service. The arson charge was never filed, but Tom Brennan's investigation provided valuable evidence for the federal prosecution. As for my cabin, I rebuilt the workshop exactly where it had stood before, using insurance money and some vintage tools I found at estate sales. The new building is larger than the original, with better lighting and modern dust collection systems that make furniture restoration much more pleasant. I installed a security system that covers the entire property, not because I expect more trouble, but because 23 years on the federal bench taught me that prevention is better than prosecution. The neighborhood is quieter now. Sandra's replacement as HOA president is a retired accountant who seems to understand that his authority extends exactly as far as the subdivision's actual boundaries and not 1 inch further. The homeowners who'd been terrorized by fraudulent fines and threatening letters have gone back to living their lives, gardening and painting their shutters whatever colors make them happy. Property values have actually improved since word got out that the HOA's enforcement practices had been reined in by federal law enforcement. I still get the occasional wave from neighbors when I drive through the development on my way to town, though I suspect some of them remain nervous about the federal judge who lives in the old cabin beyond the trees. That's fine with me. Respect and fear accomplish similar results, and after what happened to Sandra Kellerman, I doubt anyone in Willowbrook Estates will be eager to test the boundaries of HOA authority anytime soon. As I tell the law clerks who work in my chambers, the law is only as strong as your willingness to enforce it, and some lessons are best taught by example. Sandra Kellerman learned that lesson the hard way, and her neighbors learned it by watching her disappear into the federal prison system. Now, when I sit on my porch in the evenings, listening to the creek run through the valley and watching the stars come out over the mountains, it's exactly as quiet as I always wanted it to be.